buyer beware to a codified, legislated, disclosure-based system. Various documents came out as a part of that system. These three here are probably the biggest three that you may have dealt with before. The transfer disclosure statement, that's the homeowners disclosure statement under section 1102. The seller property questionnaire, again, is related to the transfer disclosure statement, another vehicle for the seller to make his or her disclosures. And then the agent visual inspection disclosure, or the AVID, as it's commonly called, or the AVID. And that is the disclosure provided by both agents in the real estate transaction that provides disclosures of what the agent observes while at the property, or any other known material defects affecting the property. So those are your big three. The way these are disclosed are all managed by contract. So often in lectures, I always encourage agents to go back to the contract, really study that CAR contract, and for home buyers and home sellers to really know what's in there as well. Because almost everything in the transaction has an answer that's provided by that CAR form contract. Quite often when disputes arise during transactions, or when somebody has a question about what their rights or obligations are within a transaction, the first place I'm going to go as an attorney is to the contract and any addenda to the contract or anything like that. And almost always you're going to find an answer as to who was supposed to have done what when in that contract. So really look at that closely and learn that contract, because that's going to govern not only your disclosures but many other aspects of the transaction. Just to give an idea of a rough outline of how the disclosure process works is right here you see we have a 17-day timeline. That's the default timeline for in the CAR form agreement. And so generally the way this plays out is the buyer has an inspection contingency. Its relationship to the disclosures is such that it's going to allow for the buyer to receive disclosures from the seller, to evaluate the purchase, and also to conduct his or her own inspections, either independently or based on what's contained in those disclosures prior to waiving that contingency. So seller makes disclosures, buyer evaluates the disclosures, and then the buyer has some options. Once the buyer sees what's in the disclosures, the buyer can cancel the contract by exercising the inspection contingency. The buyer can ask for a price change based upon whatever is in those disclosures. The seller is, of course, not obligated to change the price at all. The seller can say, no, I don't agree to do that, in which case the buyer can, again, revisit his or her right to cancel the contract. Or third, the buyer can also ask for repairs. I'll pause on this one for a minute because, as I'm sure a lot of you know, almost all real estate sales, residential property in California, are on an as-is basis. So there's a clause in the CAR form agreement that says this transaction is as-is. What that means in California in practice can vary widely, but it doesn't mean that the buyer can't ask for repairs. What it means is that in the original contract, when the buyer and seller entered into the agreement, they decided, or they agreed, that the seller was selling the property as it is. They weren't going to do any repairs, and the buyer would take it as it is. Now, you get the disclosures that are mandated by law, and perhaps those disclosures reveal things to the buyer that the buyer did not know about the property when the buyer signed that agreement with the seller. So the buyer is well within the buyer's right to ask for those repairs, just the same way they're entitled to ask for a price change. But again, because it's an as-is sale, because they're already in contract, the seller can say, no, I'm not going to do that. But there's certainly nothing wrong with the buyer asking for repairs or for a price change. If the buyer is satisfied with the investigation and the disclosures that were made, then the buyer waives the contingency and moves ahead with the purchase. So that's essentially how that all plays out in practice. Now, looking at types of disclosures, types of disclosures that a seller is going to need to make about a property. And they can be loosely grouped into a couple different categories. One is disclosures affecting the physical condition of the property. And a second category would be environmental factors. Environmental factors are varied, and they can include many different items. We'll go through a few of them, but those are the two big areas that we're going to look at. And looking at disclosures, the general rule in making disclosures is that we want to have full disclosure, all right? So current law mandates full and complete disclosure. Don't soft pedal your disclosures. So let's get some words of wisdom from Mr. Ron Swanson, and then we can talk a little bit about what we mean about that.
April were excellent. Unfortunately, every single word out of their mouth is lying. Only one thing I hate more than lying.
Okay, water that's lying about being milk. What the heck does that have to do with real estate disclosures? I think what Ron is pointing his finger at there is a very important part about skim milk, which is that fundamentally it's not milk, right? If I go to the store and I say, give me a gallon of milk, and I get 2% milk, well, arguably I didn't get 98% of what I had bargained for because I asked for milk. I didn't ask for skim milk, right? It's a silly example, but I think it does make a point about real estate disclosures in general. And that is that we want full and complete disclosure. So I often use the example of the leak roof, right? Well, how do we have a property, and in this hypothetical, it's got a roof leak, right? Every winter when it rains, we have a fruit emergency in the front. So every time when it rains, the water comes in through the roof and penetrates, it's got a leak in it, okay? Seems like that should be a straightforward disclosure, right? So let's think about ways that we might disclose that, all right? Let's think about number one. What if the disclosure that we have says roof doesn't leak, right? Have we fully and completely disclosed this issue? No, we've in fact done the exact opposite, and probably that would be considered fraud if it were to go to litigation. Now, what if instead the seller says roof leaked previously? It's a true statement, right? The roof did leak previously. Have we made full and complete disclosure by saying roof leaked previously? No. Subject to some debate, I suppose, but no, that's generally, I think, going to be construed as misleading because we know more than that. All right? So then the third option is roof leaks, right? Now we've made something closer to full and complete disclosure because we've said what we know. The roof has an active and ongoing leak. And that probably is the best way to describe it for purposes of our disclosure. To soft pedal these disclosures. Sellers of homes and sometimes listing agents of homes will often try to sugarcoat these disclosures to make them more palatable, or at least in their perception more palatable to a potential buyer. And it can be a huge mistake for lots of different reasons. One, because you know about it and it's your obligation to disclose it fully and completely. And two, if you choose, right, if you choose the roof previously leaked path, and the buyer discovers that in fact the leak was ongoing, well then what does it look like you did, right? Here you've made a disclosure. You've gone down the road. You've mentioned leaks in the roof, but because of the way you've said it, you've teed up a misrepresentation case against yourself and possibly your seller as well, because you've done it in a way that indicates that maybe you knew there was more going on and chose a language that was purposely trying to obfuscate what was really happening with the roof. So that's why it's really important that you do it fully and completely upfront. Also important to note, and this is not law, it's a little bit of psychology, but most buyers, when they are going into a transaction, they're very excited to close the deal, they're very excited to get into contract, they're not very excited to lose the property, and at this point, they're very receptive to disclosures, right? And if you tell them, hey, the roof leaks, you're going to have to get it fixed, and they go out, especially in a market like we have today, and they find out it's going to be X and such amount to fix the roof, quite often it has little impact on the deal, right? Especially in such a competitive market. However, once the rose-colored glasses come off, 2 or 3 months down the road after the transaction's over and the buyer is now in the property and owns the property and discovers the problem, the psychology is completely different. And now it becomes the buyer feels like they didn't get what they paid for, they feel like they were shortchanged, and they feel like somebody didn't give them full and complete disclosure. So that's why it's very important to do it up front. It's the law, and it also, from a psychological standpoint, puts you in a better position. So what's required to be disclosed? under both code sections is roughly within this definition here, and this comes from the statute, any fact materially affecting the value in the property. It's super clear, right? We all know automatically what that means just by reading it. It couldn't be, yeah. The legislature is always really good at giving professionals and home sellers very clear advice on what to disclose, and here they've done us all a great favor with this wonderful definition of what is needs to be disclosed. Basically what this means, and I am going to do you one even worse than the legislature did, is almost anything, right? Almost anything could fall within this definition here that the statute provides. Fundamentally, the court, if there's a dispute about a disclosure, is going to make the decision about what is material. And it's a question of fact, either for the judge if you're having a bench trial, or for the jury if it's a jury trial. But what it boils down to, if you read the case law, it's typically anything the buyer is likely to rely upon or be relying upon in making the purchase. So there's no strict definition of materiality. It varies on a transaction by transaction basis. But I think that the bottom definition is one to keep in mind. If it's something that you're aware of, that the buyer is relying upon, or that most buyers would rely upon, I think it's safe to assume that that's probably going to fall within our definition of material facts. So just here, all these line items that I have here in this slide, these are all I have taken from cases that deal with this issue of material fact that should have been disclosed and that was not. And in these cases, the court found that each of these facts was in fact material and should have been disclosed either by the seller or the seller's agent. And so physical condition of the property, that's an easy one. Liens affecting the property, right? Market value of the property, that might be one that's surprising to some of you watching this presentation, that the market value was something to be disclosed. I can give you the backstory on that case. In that case, the listing agent had a listing agreement with a seller, and the listing agreement was for $6,500. Yeah, this was a property in California for $6,500. So I don't know about any of you. I would buy anything in California for $6,500, but it's an older case. So $6,500 listing agreement. And there's some evidence in the record that the seller, there was a debt in between the seller and the listing agent. So that the listing agent was going to take this on for free to satisfy a prior debt or a favor. Not a lot of evidence that there's some aggressive marketing going on in this arrangement, not surprisingly, since no one's getting paid. So some time goes by, it doesn't sell for $6,500. So the listing agent has a conversation with the seller and says, hey, I think you should dump the property for $2,500. Let's just get rid of it and move on. You're better off. The listing agent then sells the property to his secretary, and the secretary then assigns his or her rights in the property back to the listing agent, and the listing agent goes out and sells it for $6,500, right? So the seller obviously finds out about this and gets upset, and the listing agent's argument was, well, I'm not in a position to advise on market value. That's not a material fact. She decided to sell it for $25,000. The court said, no way. In this circumstance, you had knowledge that indicated that the $2,500, which your seller was agreeing to list the property for, was below its market value. You sat on that information, and therefore you should have disclosed that. Now, it's a kind of a unique case because there's also a lot of other things going on here. Clearly, there's a lot of self-dealing, a lot of stuff the court is very much going to take an unkind look at. But nonetheless, the court disclosure of the market value of the property was something that the listing agent should have made, because the listing agent had some knowledge about what the actual value of the property was. So kind of a unique case. Consequences of financing. This one was dealing with specifically a mortgage broker. So if any of you are in the mortgage business, this is something that you should know about. Courts have held that if you're aware of certain negative consequences that could arise from financing the property in a certain way, that's something you need to disclose to the buyer. Buyer's financial strength. This is important. I've seen this issue come up in my own practice with seller carryback type financing. This case didn't involve a seller carryback, but nonetheless, arise in that situation because the seller is sort of gambling on, giving a loan of some kind to the buyer. And so if you are aware that the buyer may not be the strongest buyer financially, certainly that's something that should be disclosed. Pending litigation, that comes up a lot. And then essentially anything about the property that the seller or agent or the seller's agent know that the buyer is relying upon. And what I mean by saying that is that this kind of is the case-by-case analysis here. But essentially, if you have information that the buyer, for example, is intending to use the property in a certain way or is under a certain impression about the property that you know to be incorrect as the seller or the listing agent, at that point, you definitely have a possible disclosure obligation arising, and probably you should disclose to cut that off. So, for example, if the buyer comes to you and says, "Oh, yeah, I'm super excited about this property because I want to put a second unit in the back of it so that my mom can live there," and I, as the seller, upon hearing this, know for a fact you cannot. Let's say I went to the city last year because I wanted to do the same thing, and the city told me, "No, you're in a special use area. That's not going to be allowed," right? Now, my disclosure to the buyer is going to be, "Hey, you can't do that," but I certainly need to come out at that point and say, "Hey, buyer, I went down to the city, last year, and they told me that they weren't going to allow me to do that for this reason. So I would suggest that you investigate that if that's what your intended use is." But certainly, things like that are things that need to be disclosed. Go ahead. Mm-hmm. I definitely think that that's something that should be disclosed, right? Because you have a few different issues there. One, you have the fact that the driveway is shared, which is a disclosure issue. Right. Mm-hmm. Right. I think that, yeah, I think that that's probably a disclosure issue, and I think that, uh, I could talk with you further about how you may want to address that issue, but I think that there's a potential disclosure issue there for sure, because there are actual there's ongoing animosity between the two parties. And also, we can revisit that a little bit when we get to the second section of our talk today, which talks about disclosure disputes. So condition of major physical systems, I've just listed some here that I think are almost always going to be considered material. If you're aware of any adverse condition affecting any of these systems, it's going to be something that you want to put down. And then, the note here is, even if it seems obvious or trivial or otherwise, just assume that it's material and disclose. Again, it's for your benefit, it's for your seller's benefit. There's no reason not to disclose what you know. I have an example scenario here. This comes up a lot, and so in looking at physical conditions of the property, we have the plumbing, and that's a common thing that you might see disclosures on. What type of material is it? When was it last updated? But here is an area where people might not know that there could be a disclosure obligation. Regular plumbing maintenance. Okay, so every system in the house needs to be maintained, including the plumbing. And in the last 2 years prior to sale, let's assume your seller has made several calls to a Roto-Rooter or another plumbing service to come out and unclog the drains. Arguably, it's a regular maintenance issue. Drains do clog from time to time. Even new ones can get clogged. Is there a disclosure problem here? Well, the plumber came out and clogged it, but we never really knew what was causing it. We didn't know what was going on under the ground that was causing these backups. But they were easily addressed by Roto-Rooter on occasion over the last couple of years. So the seller doesn't make any disclosure because the seller thinks, well, this is just regular maintenance. Unknown to the seller, have clay pipes that are underneath the front lawn, and those pipes have begun to offset from one another as a product of time, and that's what's causing the clogs. Well, the new buyer comes in. Sure enough, they have to call Roto-Rooter and come out, fix the pipes, and the Roto-Rooter guy says to this buyer, well, hey, you know what? I've been out here in this area this is my territory. I've been out here the last couple of years. I've been out here 4 or 5 times to unclog the drain. I think we need to take a closer look at what's going on under the ground. And so they camera the line, they find the clay pipes, and now what does the buyer think happened in the transaction? Right? Now the buyer says, well, I bet you the seller must have known about that. They had that Roto-Rooter guy out there 5 times before I bought the property. So be careful with issues like this, because in my opinion, if this comes to your attention, from the listing agent's perspective, if your seller talks to you about something like this, and from a seller's perspective, to the extent we may have potential home sellers watching today, something that's occurred in your property, I think that you have a disclosure issue here. It's an easy thing to disclose, right? Regular maintenance on the sewer line, Roto-Rooter's been out X and such a time, no problem. Your average buyer is going to see that, and they probably, again, won't even notice it. And if they do, well, and it's material to them, good thing that you disclosed it. So you really don't have any loss for disclosing things like this. I'll give a personal thing. I recently sold a house. I had a couple of mice come in from the time that I bought it. I didn't live there for that long, and so I called a pest company to come out and, you know, do their thing. And so they came out and they caught a couple mice, and that was it. And there was probably more than a year before anything else happened. Did it go in statement? Yes, it did go into my disclosure statement, right? Because I didn't want this scenario to happen here. You know, it's something that came up, something the buyer should know about, easy to disclose, just put it in there. Environmental factors. These are a little bit, I think, probably more difficult for some people to identify. Some are pretty straightforward. Noise, airplane, train, otherwise. I'll pause on this train. We had a case that I dealt with once that it was a train that ran behind the property, right? There were train tracks behind the property. You could see it from the back of the house. So from the seller's perspective, there's nothing to disclose, right? You walk out in the backyard, there's the train tracks. It doesn't take a genius to figure out the trains go up and down there every once in a while. Well, no disclosure about the train noise, right? So what happened? Lawsuit goes down, and now we've got a disclosure issue because nobody disclosed the train noise in the back. I know it may seem ridiculous, and, you know, probably cases like that might be easier to resolve. Maybe they have less gravitas, but nonetheless, you know, the disclosure forms ask for this information. It's something you know about. So even if it kind of seems like overkill, always err on the side of disclosure. Street traffic, annoying neighbors, to go back to your point, that's a potential disclosure issue. The reason why this is if the neighbor's conduct goes beyond sort of being nosy into what we would consider a legal nuisance, and I won't get into the definition of that, but there's a potential for that. You want to make sure that you've covered yourself and your seller by making that disclosure. Known criminal activity in the neighborhood, schools and churches, those are always a big one. If there's a school down the street, a church down the street, be on the lookout for potential traffic problems, parking problems that might need to be disclosed. Believe it or not, I've seen lawsuits filed over church parking, right? You wouldn't think it would happen, but it does. And then your typical natural hazard disclosures, fire zone, earthquake, and flood. These are very important and becoming more important and more important with raw land. I can tell you I've dealt with a few cases that have had potential disclosure issues with respect to raw land, where a updated and accurate natural hazard disclosure, there has been a dispute about whether or not that was provided during the transaction. So if you are on the listing side or the buyer side of a raw land transaction, or if you're looking to buy or sell raw land, make sure that at some point one of the two sides produces a new updated version of one of these reports, that the other side gets a full and complete copy of that report, and that you importantly have a signed record in your file that went over. Because these issues with respect to raw land can cause a property to be completely undevelopable. I'm not even sure if that's a word, having said it, but I think you know what I'm saying. You know, so just make sure that one of those makes it across. And prior maintenance and repairs, we touched on this a little bit with our plumbing example, but I'll go back to it again. This is always a source of question during the disclosure period. I'll use my roof leak example again. Here we had the same leaky house, but this time the seller, you know, repaired it a year before going to sell it. Hasn't had any problems. Last rainy season was fine, dry as a bone. Is there something to disclose? My opinion, given the proximity of time and the previous problem, yeah, that's probably something that the seller is going to want to disclose. There is admittedly a mix of case law on this issue. There are some treatises out there that will tell you, no, you do not need to do it. If the seller has fixed it and it appears to be fixed, and in good faith, you know, the seller has no reason to believe it was not fixed, then you don't need to disclose it. I think that could arguably be true but why have the argument? It's really easy to say, I fixed the roof, or I had somebody work on the roof. What you want to be careful with is the language worth is repairs versus repairs done. So consider disclosure number 1, the roof leaks were repaired, okay? Or disclosure number 2, repairs were done to a previously existing leak in the roof, or something along those lines. Well, the first, you're committing to that fact that the repair has been done and it's complete and it's perfect. Most sellers aren't contractors. Most listing agents aren't contractors. Really not in a position to evaluate whether or not this repair was done adequately and whether or not it's going to stick, right? Perhaps maybe we fixed part of the problem, but another part we don't know about isn't fixed. So the safer language to use is to indicate that you have performed some repairs and that there was a previous leak without kind of warranting that contractor's on that leak. So just be careful with that language. And then, not to bore you to death, but I'll give you a little bit of the case law that's split on here. So on repairs, what some of the courts have said is that when the repair is affecting a sort of fundamental system of the property, in the case I'm thinking about dealt with a foundation issue that had been previously repaired. And the court found that the seller in good faith believed it to be repaired, but because it was such an integral part of the home and such a big deal, right, when you've had to have foundation repairs, that repair should have been disclosed because the buyer should have had an opportunity to evaluate what repairs were done and whether or not those repairs were adequate. Now, it's pretty unique because we're dealing with the foundation of the home, which is, the foundation. It's one of the most critical components of the home. But nonetheless, there is some law out there to suggest that. So certainly, if you're dealing with repairs that were done to a fundamental component of the house, foundation, I think roof, anything structural, you want to make sure that at least the repair work that was done was disclosed. That way, you're putting it out there, buyer can look at it if they want, and then you're done. Death in the property comes up a lot. It's really actually pretty easy. It's no need to disclose it if it's been more than 3 years since the date of contract. Okay, date of contract. So the date the buyer makes the offer. 3 years prior to that date, there's no need to disclose death in the property. The caveat there is if you get a direct question, or if the seller gets a direct question from the buyer or the buyer's agent, you have to answer honestly. So even if it's outside of the 3 years, it's not a complete shield of disclosure. You still have to disclose. In the back. Yes. Well, I think if you're not involved in whatever pending or contemplated transaction in any way, right? If you're not representing anybody at that time, if your involvement with the property has terminated, i.e., whenever you were involved, that escrow is closed. You're no longer working for anybody. I think you're safe to defer the question to whomever is actively involved with the property to answer, right? But as a general rule, if you are involved in the transaction and you're asked the question and you know the answer, even if it's outside of 3 years, you do have to say, you do have to, affirmatively represent. I would, if I'm not actively involved in it, I would probably tell them to speak to those people who are actively involved in it, because you're not representing anybody in that transaction. Right. Exactly. Mm-hmm. Now, I'll say I wouldn't have any problem with you telling the person about that. I mean, I think you're well within your you know, within the right just to answer the question. Yeah. So if you're inclined to do so, yes. I mean, there's no problem there. And this subset of this is also HIV/AIDS. So there's a special rule. I think it's pretty well known by most professionals at this point. It may not be known by the general public necessarily. You don't have to disclose if somebody was living in the property and they had HIV or AIDS and or died of HIV or AIDS related complications. Now the death itself is still subject to disclosure under the same rules we just discussed, but the cause of death as HIV or AIDS is not. Infestations, same thing. This goes back to what we were talking about before. If you've had pest problems in the past, just disclose them, put it out there, put out what you've done, let the buyer evaluate it for themselves. Remodeling work, this is another big area of inquiry. Again, just make sure that if there has been remodeling, that your seller understands that they need to disclose that what they've done is subject to permits or without permits, and then they put it out there. I saw one disclosure on it once that went to litigation actually, and I thought it was great for the seller because they'd done such a good job on their disclosures. And actually, I think eventually the case sort of went away, but they actually had an addendum TDS where they went through every single room in the house and listed out, I put in a ceiling fan, I, did this, that, and the other thing, and then in parentheses by each one, whether or not it was done by themselves or a contractor, who the contractor was, if a contractor was used, and whether or not, to their knowledge, permits had been pulled. So, I mean, that's the ideal. I don't know that it's necessary for every property, but they had done a lot of work on their own, so I think in their case it was, and it turned out to be very beneficial for them. Yes. Mm-hmm. No, if it's 3 years, then yeah, and unless you, of course, get a direct question. Well, now you're kind of going into a gray area where I think that there could be a split, because if it's a material fact, then yeah, it's going to need to be disclosed. So it just depends on, I think, there's more of a case-by-case analysis to be done there. Little known pitfalls, disclosures. Number one, permits, right? Just, I think the simple rule is if you know there weren't permits, that's what you say. If you know you did get permits, that's what you say. But avoid, as a seller or a listing agent, sort of putting your stamp of, oh, this doesn't need permits or this does need permits, because it can vary quite widely from city to city. And some of the stuff that can require permits is actually kind of, I think most people really, I mean, changing your bathroom sink in some cities requires a permit. So, I mean, just be careful about representing what's permissible in that regard. Square footage, generally just stick with whatever the county gives you. Be very careful straying from that number, because then it's you are the one who's going to ultimately have to sign off on it. And so, by altering that number as a seller, as a listing agent, you've adopted this new number, and now you're going to have to defend it. And with square footage, it's not always easy to do. Mm-hmm. I would, from my perspective, being conservative, I think disclose that the room was added, right? And then have your seller disclose whatever about that room is material, i.e. did the seller get permits, did the seller not get permits when the seller did that room addition, and then leave it to the buyer to determine what that adds to the property, okay? And so, put out what's there, and in a lot of cases, if the addition was done with permits and subject to plan review and all that stuff, the county numbers are going to reflect what that is. That's not always true. Sometimes there's mistakes in that record. And that's yet another reason why you don't want to go down that road. I had a case once up in the North Bay, and the property was listed and sold like 3 times over the course of, I think, maybe 10 years. And it was listed and sold by the same brokerage each time. Different agents, no real connection between the sales. But every time the number provided by the county for the square footage of the property was different. Okay, so you just don't want to assume responsibility for these numbers. It's best to just let those numbers stand on their own and let the buyer investigate what it is. Right. Right. I think that's a fair statement. Yeah, if you have those numbers and they conflict, certainly highlighting that for the buyer and saying, hey, these are what the varying numbers say, that's fine. And I don't mean stick with the county numbers in the sense that I mean take those numbers as true. What I mean is that if those numbers are there in the public record, that's just what they are. And you're not verifying them. There's tons of disclosures in the transaction documents that says you're not verifying them. It's when you start adding your own numbers or giving potential credence to other numbers that you've sort of acted counter to the standard disclosure, which is that you're not verifying the number. Once you put out your own number, the idea is that you've put something out there. Now it's to you to justify why you put it out. So you just have to be very careful about doing that. And then a couple of things that I wanted to hit on. As is contracts, again, as is doesn't mean I don't have to disclose. Just make sure as a seller you understand that, and as a listing agent that your sellers understand that. Oftentimes sellers don't, and when disclosure disputes come up, lo and behold, the first things that they say is, well, I was selling the property as is. Well, that doesn't mean that you don't have to disclose, not at all. In fact, the statutes specifically say that as is does not get you out of your disclosure duty. So it's very important that your sellers understand that, because I know that not all of them do. Non-contingent offers. This isn't really a disclosure issue, but it is something to look out for. I've seen more litigation develop, and it's because buyers go in, no contingencies, and they're doing it to be competitive. Arguably, they have to do it because the market is so competitive. But then they find stuff wrong with the house, and then later turn around and sue the sellers, saying, well, yeah, it was non-contingent, but I was entitled to rely on your disclosures, which is true, legally speaking, and you didn't do a very good job. And that may or may not be true, but that's a fight that comes up later, and it can happen more often in non-contingent offers because the buyer is doing less independent investigation. So if you're gonna take a non-contingent offer as the listing agent, really be sure that the seller have been pretty thorough, or as thorough as you can be in those disclosures. Go ahead. Right. Right. Mhm. Right. I think if it's a conversation that you've had with your seller and they said, yeah, that's an addition, and I don't know if it's permitted or not, then that's all you say. I mean, that's the seller met their obligation, you've met your obligation. On the buyer's side, it could be different. I won't delve into that. That's more of a fiduciary duty issue. But from a disclosure perspective, yeah, as you know. 11th hour disclosures. This comes up. If something comes up and you realize your sellers failed to disclose something or potentially failed to disclose something, amend it. The contract provides for a vehicle to do this. The law provides for a vehicle to do this. You amend the disclosures. It does reopen a potential contingency for 3 or 5 days, depending on how you deliver that amendment to the disclosures. But what this protects you from is that a buyer is allowed to close. If a buyer discovers a bad fact about a property and there's arguably some fraud or non-disclosure, they can close escrow and still sue the seller. As odd as that may sound, they can close knowing of the existence of this defect and still sue. So if you've picked up on this, make the disclosure. That can impact their ability to, the viability of any claims they may make later, because now you've made a disclosure, a legal disclosure, and they've had this contingency period to evaluate it. So just make sure that if anything comes up, don't hold off, get it out there. Now I'll go quickly through. We're cutting it close to the wire here, so I'll try to trot through the non-disclosure dispute process. This is not something I normally do in my disclosure talk. I thought it would be nice to try to give you all an idea of what the process looks like and to give potential home buyers or sellers an idea of what the rights may be, because this doesn't occur in a vacuum. All these disclosures are for a reason, and they're to protect you and your seller from potential liability later on. So I think it's good to know the process. So typically, a dispute arises when we have the discovery of a defect in the property. The buyer then initiates an investigation and gets some evidence that he or she feels indicates the seller maybe knew about this, and so they make a demand. And it comes in the form of a letter from another lawyer saying, hey, you know, you guys, this is going on with the property, and you guys must have known about it, and here's why. It may be total fabrication, and you may have a complete defense. But for those of you who are sellers of property and you get one of these letters, I've put in red here, do not reject a mediation demand. I can't tell you how often I see sellers getting these demands and they say, well, this is a bunch of hooey. I'm not going to talk to this guy. And so they write a letter back saying, you know what? None of this is true. I'm not talking to you. No, I'm not going to mediate. You know, leave me alone. They may be right. They may be right. That may be what's really going on. But the contract requires mediation. And if one of the parties to the contract will not mediate, that party loses their right to recover attorney's fees in any later dispute, in any later litigation. So that email, that gut response of, I didn't do anything wrong, leave me alone, while completely justifiable in certain circumstances, may cost you a lot of money in the future because you are contractually obligated to mediate the case. So important to know that if, as a seller, you get one of these letters, make a response that includes, you know, a willingness to mediate. And if you are an agent who gets one of these, consider the same. As an agent, you're in a bit different spot. You may or may not be required to mediate depending on who's making the demand. If you're a listing agent and the demand is by your seller, there is a mediation clause there. So look out for that. And just know that don't honor your gut reaction of, I'm just going to tell this guy to go walk away, because that's generally not going to help you, and it could very much hurt you down the road. Most cases then proceed through arbitration or litigation. Arbitration is just an out-of-court private process, private judging sometimes called, and litigation is an action in court. Arbitration has some costs associated with it, but it's generally considered to be faster and more economical than litigation. Go ahead. Right. So how that works is this. I'll just my own practice. One of the first things we do this a lot, so we know about this. I can't tell you how many attorneys screw this up. They get a buyer in, and the buyer finds it's non-disclosure. Attorney thinks that they've got a great case, so they get really excited, and being an attorney, draft up a legal complaint and runs down to the courthouse and files it right away, thinking he's got this smoking hot case, and now he's going to stick it to the seller. And what he has just done is cost his or her client the right to recover attorney's fees. So mediation doesn't mean you have to settle. All right, it just means you got to go. You have to show up in good faith, talk about the case. If either side doesn't want to settle, there's no obligation to settle. The obligation. So I can't tell you how many times I've seen attorneys screw that up, and especially attorneys who don't do a lot of real estate work. They're not aware of how the clause works, and they file litigation, and they potentially put their client's claim at risk. So to answer your question, you know, there's no problem with that at all, and that's in fact what the contract requires. So when the buyer can act before close of escrow, so they can, as I said, plan to close and seek damages, or try to get out of the contract through a mediated process. You know, so the buyer and the seller negotiate, essentially terminate the transaction and move on. After close, how long do they have to act? Between 2 and 4 years. That's a very rough statement of the statute of limitations. That can change. It can be longer because it's not always from the closing date. If there's fraud or active concealment, it can run from the time that fraud is discovered. But in any event, 2 to 4 years is the general rule. They can sue for damages or for rescission of the contract. Now, what that means is simply that the contract is undone, the house goes back to the seller, the money goes back to the buyer, and everybody, in theory, is put in the position they were before the contract was ever entered into. So that's a rescission. So there's two types of claims that get with as a seller or listing agent, accidental or intentional. Accidental is by far the most common. It's less common to see intentional claims. And breach of contract can also be intentional, but generally, breach of contract would be an inadequate disclosure by the seller or negligent misrepresentation, i.e., I say the property can be used for something and it can't, and I say it thinking it's true, but I really don't have a good basis for making that statement. Maybe I'm going on rumor or conjecture, but in any event, I represent it to the buyer who believes it, and they buy the property, and now it turns out it's not true. So that's the one that really you want to be careful with, and that goes back to what we were talking about disclosures before, and really knowing what you know about the property and what you don't know about the property, and limiting your disclosures to what you know, and not making any affirmative statements about the property that you haven't really vetted or have a good basis for asserting. And that goes, same is true for both listing agents and sellers, because negligent misrepresentation is by far and away one of the most common claims. Fraud and misrepresentation, that goes back to our leaky roof example we were talking about before, our skim milk problem. That's when that generally comes up, when a disclosure has been soft pedaled or drafted in a way to mitigate its impact. That's quite often when you see these fraud claims coming up. So again, be very careful with that. We've gone through mediation, so we know what we need to do there. Buyer suing the seller is by far the most common lawsuit that arises out of transactions. And then usually what happens is the seller will then turn around and sue their own agent. That's a claim based on the seller agent's fiduciary duty. It's a direct claim. And then the seller may also sue the buyer's agent for indemnity, and that's what we call an indirect claim. And then what that means is that I may, as the seller, say, well, I did my job, and if your agent had just done their job, then I wouldn't be here. So you need to compensate me or indemnify me for any losses I may owe the buyer. So that's kind of how it regularly goes forward. So some of the things that I would advise people to do when they get these types of lawsuits, other than trying to get the case into mediation, if there's a mediation clause, which there almost always is to, number one, put your insurance on notice to the extent you may have it. Most agents and brokers have what they call errors and omissions insurance. Let the carrier know, even if it's not going to get turned over to the carrier for handling, it's important that you put the carrier on notice, because they could potentially use that as a way to deny your claim for coverage later on. So you want to let them know, hey, there's this dispute. Even if it's something that you think you may be able to resolve in-house or for a low cost, just give them a heads up that there's a potential claim. Same's true with homeowners. Homeowners insurance may cover some of this stuff, so just put your carrier on notice. It's less common, but I have seen homeowners pick up some claims. But in any event, it doesn't cost you anything to let them know, and it preserves any coverage you may have in the future. It's a very bad thing to lose coverage simply because you didn't tell anybody this was going on. And the reason why is that most of the time, if coverage is allowed or even subject to dispute, that the insurance company is going to provide you with counsel. And that is going to be one of your biggest expenses in dealing with one of these. So if you can get some help paying for your attorney, that's a great thing. For those real estate salespeople here, always let your broker know. Let your broker know right away. They're going to be your greatest resource as to how to solve the claim. So let your broker know, your manager know, and they'll be your best resource in getting solved. Oftentimes, the broker can talk to the broker, and they're able to work out the problem amongst themselves if it escalates up the chain. And then decide if you want to participate in mediation. Almost always a yes. I would say almost always a yes, even if you're not obligated to do it. And that's because quite often this is the way most claims get resolved. And if you can resolve it in mediation, it's always going to be cheaper than paying me. I like to get paid, so I would appreciate, if you pay me to litigate, that's great, but certainly a mediation is going to save you a lot of money. So what do I do when I first get a case? I look at it in two ways. I look at it from a standpoint of liability and damages. So liability, we're talking about, was there a duty to disclose, and did you meet that duty? And that's what we were covering in the first half of our speech. So that's what I would look at. I would look at all those same things. I would say, okay, well, what did you know about the problem? What's in the disclosure? What's in writing? That's really what's going to drive it. What do we have that shows that we met this duty to disclose? There's some defenses to that, open and obvious. To go back to our train example, that was one of the arguments, of course, in that case. Well, look, it was open and obvious. Not always the best defense, but it's certainly a defense. Disclosure from another source, it's in the home inspection report, it's in the pest report, or otherwise. Lack of knowledge, if I don't know about it, I can't disclose it, and I'm not required to disclose things I don't know about. So from the standpoint that the seller never knew about it, well, there's no knowledge. And then no damages. So that's the second area of any big case. And this is one of the things that I personally like to take on early on. What is this case worth? Because if you're liable, and I assume that you did something wrong, if the problem only costs a couple $1,000s to fix, well, then I don't think that we have a really large issue in the grand scheme of things. Conversely, if I think that you did a great job and you're probably not liable, but the problem is real and is going to cost $100,000 to fix, that might affect how we evaluate how to deal with this case too. So I want to know what this is worth going out the gate. And so what that is controlled by Civil Code 3343, and it's diminution in market value. And what that's a property worth any less than what the buyer paid for it because of the existence of that non-disclosed defect. Now, this is important because oftentimes we talk about the cost of repairing the defect and that as the driver, but that is not the measure of damages that's applied generally. It's this diminution in value. So, for example, if we have a minor roof leak and it's established and agreed that this roof leak only costs $3,000 to fix, is it going to devalue the property by $3,000? Arguably, because now I know as a buyer I have to pay for that. But I think an appraiser could very credibly testify in today's market especially that maybe not. That maybe had the buyer known about that, because the market is the way it is, that's generally not going to work a diminution in value equal the cost of repair. So maybe it's $1,000 or maybe it's $0. So this measure can quite often reduce the value of a case, especially in a market where you have a lot of competition, because their appraisers are going to have a more difficult time justifying that the property was worth that much less based on the non-disclosed defect. Punitive damages, they're only relevant if you did it on purpose. I'm going to assume everyone watching today's show would never do anything like that on purpose, so we don't even need to worry about it. But again, be careful with those disclosures, because if you're not picking your language carefully and it looks like you've been trying to hide something and you have the specter of intentional misconduct, you could add punitive damages on top. So you take what is kind of a favorable measure of damages and turn it into a very disfavorable one by not being careful, again, with your disclosures. And then attorney's fees, this is always on the table because they quite often outpace what's at stake. This is another reason why I advocate for early analysis and resolution, because it's a shame when a house has a problem and perhaps we all agree on some level that there may be some dispute regarding liability. We want to get this resolved. And this only is going to cost $10,000 to fix. So with everybody in the room, maybe we can split it up and everybody feels okay about it. But now everyone has spent $25,000, $35,000 individually on each of their lawyers. So what was a $10,000 case has now become a $120,000 case because all the lawyers want to get paid. So, you know, be careful with these, mediate early, and note that attorney's fees are awarded after a lawsuit. So a lot of sellers will drive forward with their, or buyers will drive forward with a lawsuit expecting that they'll get their attorney's fees back at the end. However, when you win, you get your judgment, and then you have to go back to the court and ask for attorney's fees. Now, oftentimes the court's going to reduce that amount for many different reasons, which I won't get into, but if I'm claiming $50,000 in fees, the court might take a percentage off of that for varying reasons, including how the litigation proceeded, how successful I was, how much money I recovered compared to how much I was claiming. And so it's not guaranteed that you're going to get a dollar for dollar return on that. Court can reduce it and almost always does. And then again, when you win a case against a seller, what you are winning is a piece of paper that says the seller owes you X amount of dollars. And then the attorney's fees get added to that. Nobody takes the seller from the courthouse down to the bank and says, cut a check for this amount of money. You basically stand in line like any other creditor, like the phone company or the mortgage company or anyone else who's owed money by this person. And if this person is not inclined to pay their debts, then you may not get that money. So again, another reason why to carefully evaluate your claim upfront and try to mediate or otherwise resolve it as quickly as you can. It's more likely that you're going to get what you want. So one thing I like to do is all these numbers for damages, okay, are done by experts, usually an appraiser and a contractor or other construction professional of some kind. So what I like to do is when one of these cases comes in, I want to know first, what's my liability position? I determine that by talking with the seller or the agent about what was disclosed and what was known. And number two, I want to know what's the damages position. So we look at how much is this thing, really going to generate? Is the defect really valuing the property? So you need an appraiser and you need a construction industry professional to get out to the property and look at it. I like to do this as early as I can, assuming that the case merits it and assuming that the person whom I'm representing can pay for it, because this number is really not going to change as the litigation goes on. We may discover facts that indicate liability or discover facts that indicate there's no liability. That may change. But if the defect exists and it has a cost to repair, that's generally going to be it, assuming you've got a competent expert looking at it. That number is not likely to change. And so it's important to know what you're fighting over before you spend a ton of time and money fighting over it. So role of lawyers, what do we do? Well, I'd like to think we are expertly skilled in mediation. We do it a lot. We know how the process works, and we can help guide you through that. Looking at issues to see whether or not they're material. Identifying, is this something that I really need to be concerned about from a liability standpoint? And that can save you some time and money up front. And then advise when you're at risk of a lawsuit or having a claim, right? So if there is a dispute arising, there's quite often a way to cut that dispute off before it gets out of control, right? Even if that's me telling you the bad news. You walk into my office, I look at it and say, you know what? This was a mistake, no harm, no foul, but you've got a problem. But here's the cost. Let's get some money in front of it right now and shut it down before it gets out of control. Or avoiding the claim in the first instance, right? This is, if there's a question about, do I need to disclose something, or somebody's done this in the transaction, or the transaction's sort of gone off the rails, how do we get it back on track? Don't be afraid to bring somebody in to advise early on, because again, these problems are best addressed early, and quite often if we can get in during the transaction or when the question arises, you can cut off a lot of problems in the future. So that's it. I'd encourage you to take a look at our website, brewerfirm.com. This webinar will go up on there when we're done today. Clayton will upload it so you guys can watch it. I know it was so thrilling today. I'm sure you can't wait to do the part 2 and get some popcorn and watch it at home. But all the sites will be there for you too. So feel free to refer your clients to look at it. For those of you who are watching who may be buying or selling a property, feel free to take a look at it, and don't hesitate to contact us if you've got questions. All right. So with that, I'm going to wind down. I know we're a little over time, so I'm going to let Clayton, I think, probably wind up the webinar, and unless you want to do some Q&A, or Tom. Okay, 5 minutes. All right. Okay. I think the best way to handle pre-sale inspections is to simply provide them with the seller's disclosures. And if you want, I mean, this advice is already in the standard CAR forms, but with the advice that buyers advise to do their own inspections, and that you're just providing inspections. You're entitled, under Civil Code 1102, the seller is entitled to provide those reports without liability. So I think that by kind of going beyond that, there's a potential even that if you ask the buyer to adopt the report or pay for it, that you may be generating liability where there isn't any. So I would just turn them over with the disclosures. Yeah. Anything else? All right. Go ahead. Mm-hmm. So the answer is it depends. I know that's a terrible lawyer answer to give you. It's because we don't like to say things affirmatively. Again, that's why I put the disclaimer at the front of the presentation. But no, I mean, to answer your question is, it can be long, and it depends on who is being sued, or who the claim is against, and what the nature of the claim is. But generally speaking, when you see these longer periods, it's because there's alleged fraud in the transaction. And so this rule that we have in California called the discovery rule applies. And so then your period runs from the date of discovery. And how far it runs from there, it depends on against whom the claim is being made and so on. But generally, it would be 3 years from that date of discovery for a fraud claim. And I have seen personally claims arise. I think the oldest one I got was it arose, I want to say, 8 years after close of escrow. Obviously, there's still argument you can make, but that's a stale claim, and it's for many different reasons. But the longer that you get from close of escrow, the less likely, the less viable that argument for the discovery rule becomes. So I would say that when you're at 10 years out from close of escrow, there's certainly some very good defenses to be asserted that the limitations period has run, even if there's allegations of fraud. Does it make sense? Yeah. I would say first of all, the HOA disclosures are mandated. They're part of the contract as well. And generally, the disclosure packet that you get from the HOA would include that kind of information. And so I think if you're aware of the issues affecting the reserves of the HOA, then that's a disclosure obligation. In fact, I have dealt with a case that had that issue in it before, and there was the HOA was studying dry rot that was affecting the properties in the complex, and there was question whether or not the HOA had enough money in the reserves to pay for what could potentially be the cost of repairing this dry rot. There were a couple of issues at the time of the sale. They didn't really know what that cost was going to be. They didn't know when it was going to happen. The disclosure didn't get through, and then it was determined that, in fact, yeah, it was a massive problem, and there was a special assessment levied on each unit in the condo complex, as a result of this dry rot problem, because there wasn't a sufficient reserve to address it. And obviously, the buyer was understandably upset about not knowing about that before closing escrow. So these issues can't come up. But yeah, if it's something that's, again, the rule is desirability and value of the property, certainly not having reserves sufficient would be in that category. Mm-hmm. Wait, so if the seller believes that the work was done in good faith, can the buyer go back and sue the contractor? If it ends up being a defect, I would say that again, it depends. Some respect to do with the timing, but certainly I think there's a potential, vehicle for relief there if the work was not done as it should have been done. Anyone else? Right. Well, I would say I'll answer your question this way. First of all, the TDS itself says that that those reports are sort of integrated into the disclosure. And specifically with the natural hazard disclosure report, that report encompasses some of the things that are part of the civil code that the homeowners require to disclose. So the extent that it's in that natural hazard disclosure or JCP report, it's kind of unfair to call them natural hazard disclosures these days because they go certainly farther than that, but those are integrated into the seller's disclosures. So I don't think that the seller needs to go through those reports and issue spot items and then put those back into his or her TDS or SPQ. I think the combined disclosure is sufficient. Right, but what I'm saying is that the form itself already refers to the report. So you can have him, I think, sign receipt of those reports, or, seller has made as part of his disclosures the following reports, and then you know, number it out and have the person sign it. I think that's probably the way to do it. Right. And what that means. No, I would say material is probably the word I would use rather than significant. I think that what they're trying to get at with that form is materiality. So I would just treat the language as the same. You know, if it's something that you know the buyer is relying upon, or that a reasonable buyer would find important, then certainly it's going to be something you disclose. Right. Yeah. So, yeah, I would say that if there's something affecting, you know, one of the, you know, sort of integrated structures of the house, if there's something affecting the foundation, the windows, the doors, the plumbing, the electrical, and you don't disclose that, and it's an adverse condition, and it comes up in a dispute, and you say, well, that wasn't significant. You know, I didn't mind that, you know, sparks shot out of the light switch every time I flipped it up. You know, that's probably not going to fly, right? So. Yeah, say if you're aware that it was not done by a licensed professional and it was not done without permits, then that's probably something the seller is going to want to disclose. So. Yes. All right.
Thank you very much.
Thank you. All right.
Wonderful to have a resource available to us here.
Right.
And,
Thank you, Tom.
Thank you very much.
Yeah, and feel free to contact us anytime. We'll give you some cards, and again, check the website, and anything we can do to help you guys.